The broadcast is now starting. All attendees are in listen-only mode.
I'm going to start over because I don't know if you heard me from the beginning. Hi, this is Amy O'Hara. Welcome. We're going to get started in just a couple minutes. As I still see that we're having people join us. So just sit tight and give us about 2 or 3 more minutes. Thanks. Hi, welcome for today's webinar presentation. I'm Amy O'Hara. I'm a partner at the law firm of Littman Krooks, and I'm going to talk to you about common mistakes in estate planning and things for you to think about and consider from time to time, with respect to your estate plan. Just a couple housekeeping items. In the chat in the screen that's probably on the right side of your computer monitor, I think you'll have the ability to chat, to ask questions, and then you want to do it like there should be a down arrow as to who to ask the questions to, and I would suggest that it says that you check the box organizers and panelists only. You could ask your question throughout the presentation. I will not be looking at it until the end of the presentation, just to keep the flow going, and then at the end we'll have time for questions. And then I think also on your log-on screen, if you have problems with that, on your log-on screen, you probably have Kian Mama's email address for contact information. You could always email her and she will check towards the end of the presentation. I expect the presentation to be about a half an hour or so, and then time for questions. So, welcome. Oops, sorry. Hold on. There we go. Okay. So, common mistakes. This is I always like this quote as an estate planner from Benjamin Franklin. If you plan to fail, you are planning to fail. Excuse me. If you fail to plan, you are planning to fail. A discussion of death and incapacity is certainly not a comfortable conversation to have, but it's essential that you speak with your loved ones, because when you become ill and then at your death, if they're not aware of what plan you have in place, it could lead to a lot of additional work. So it's important to get your proper documents completed correctly, have them organized, and discuss with your family, as I'll mention, time and time throughout this presentation. So what is estate planning? Estate planning can take various forms, and it depends on your goals and what's important to you and your family. So it could comprise of the distribution of your estate, of your assets upon your death. Perhaps you want to avoid probate. I'm going to go into a little bit about that. Asset protection, if we're looking at it from an estate tax planning perspective or a Medicaid planning perspective, what's important to protect assets from. perhaps a marital or your child is not in a proper marriage or a strong marriage, and there's concern about a divorce, and you want to protect any inheritance that your child may be receiving from any equitable distribution that may result from a divorce. And then planning for your incapacity, advanced planning for financial affairs and healthcare decision making. So just a couple of, because I'm going to get into the different documents that, the basics, essentials, documents that we must have, but to talk about like probate versus non-probate. So I find clients are more interested in trying to have their executor file their will in the court when they die, meaning go through the probate process for delay, for expense, for many reasons. And so they come to us wanting to know how we could avoid probate. And it's important to look at all of the assets. So with probate assets, those are assets that you own individually in your name that are not jointly titled with other individuals and do not have a beneficiary designated or are in trust. And those assets are typically passed through your last will and testament at death. Assets that are not considered probate assets are assets that may be jointly titled with another individual and or have a beneficiary or be in a trust. Probate is a court-supervised transfer of assets at your death. And your last will and testament governs the distribution of those assets. Probate typically lasts between 9 months and 2 years. So that's very common for the time period to going through probate until ultimate distribution of estate assets. There are attorney's fees involved, executor's fees, court filing fees, and you also expose your will for potential contest. If there are family members or other interested beneficiaries that feel that they are not being treated fairly pursuant to the terms of your will, and they may have an opportunity to contest that. It's also a public process, and not everybody wants to keep their will, the distribution of their estate public. It's in New York. You could go down to the local surrogate's court in the county and look at somebody's will and look at who the attorney is and get a sense of what the assets are. So it's a public process. Your last will, so estate planning essentials, last will and testament. It doesn't go into effect until your death, and your executor actually is officially appointed through the probate process, and the court appoints the process. It doesn't plan for any incapacity during your lifetime, a will, and similarly, if you create any trusts under your will, what we refer to as testamentary trusts, they don't go into effect until your death, and it's court supervised at that point. Whereas there is also various trusts, such as revocable trusts, that can go into effect during your lifetime to plan not only for the disposition of your assets at your death, but to help for any type of incapacity that you may face. It's easy for somebody who you have named as a successor trustee to be able to kind of step into your shoes within the trust structure and speak with your financial advisor, make certain financial decisions, pay for your bills in their capacity as trustee. Similarly, a revocable trust is often private and not made public. So there's a sense of privacy there, and it really minimizes any type of a will contest. Does not completely eliminate the possibility, but it minimizes it. Revocable trusts, though, are revocable. So any asset that you put into the trust, you have the ability to amend the trust. You have the ability to revoke the trust. And they are not there to serve for any type of estate tax planning or Medicaid planning or asset protection. That's what we use irrevocable trust for. But with an irrevocable trust, you have to give up control. So you're moving your assets from your individual name into an irrevocable trust, and you're giving up control. You're not going to be able to take that money back. And so when we're talking about the will and the trust, and it's important to think about all the interplay of all of these and make sure that whatever the strategy is, that it works together. You know, sometimes people will, I'll meet with clients and they'll say, well, I'm avoiding probate because I have my spouse or my child listed as a joint owner on my bank account or my house. Well, joint tenancy with right of survivorship is not without its problems as well. For example, if it's a home jointly titled with a spouse, it only postpones the probate until the death of the second spouse. Okay. Also, if you have a falling out, say with a child or somebody else, it's sometimes difficult to remove a co-owner on an asset that has their name as a joint owner on it. It exposes assets to the deaths of the other joint tenant. And also you may unintentionally disinherit other beneficiaries that you want to leave assets to. And so that kind of leads me to my beneficiary designations, and that it's essential to coordinate all of this. You know, under your will or your revocable trust, you provide for a mechanism of the distribution of your assets upon your death. And let's say there's various percentages that you may leave your estate to various individuals. Well, oftentimes life insurance and retirement benefits such as a 401k or IRA pass outside of your will or a trust. And it's very important to coordinate the beneficiary designations and the percentages of the individuals who inherit those assets upon your death. And sometimes they are different percentages, and that's certainly fine, but it's important to think of the entire picture and to coordinate that. And to also, you know, work with your financial advisor and your accountant and your attorney, that we're all part of the team to benefit you for proper planning. The other essential estate planning is advanced directives. Power of attorney, which deals with financial management of your assets. If you typically a power of attorney goes into effect when you sign it, but the real goal is that it's durable, which in New York we have durable powers of attorney, which means it survives any type of incapacity, and that whoever you designate as your agent will be able to handle your financial affairs if or when you become incapacitated. Now, if you have assets in a revocable trust and you have a trustee that manages those assets, the trustee has control over those assets, and an agent under a power of attorney typically has assets that are, they handle your finances that are outside of the trust. Your agent under a power of attorney and your trustee under a trust can be the same individual. They do not have to be different individuals. In fact, it's probably advantageous to have them to be the same individual, unless if we're dealing with a corporate trustee on a trust, because that way they could help you in various capacities. Healthcare directives. So it's important that, and these documents are actually very state specific, including a power of attorney and a healthcare proxy. New York State has a healthcare proxy document that you could complete and put on file with any medical providers that you see regularly. And that is a document that goes into place when you're unable to make your own healthcare decisions. And it could be not only limited to end of life, but ongoing decisions, you know, dealing with any type of incapacity and visiting the doctor or making medical appointments. Your healthcare proxy or agent can do that on your behalf. A living will, on the other hand, is not a New York State statutory document, but I like to say it's a set of instructions to your healthcare proxy about what your wishes are concerning end of life. If you do not set forth either verbally or in writing what your wishes are, then your agent has to do what's in your best interest. But New York State goes by what's called a substituted judgment standard. and they have to substitute their own judgment for what you want. And that's where a living will is important, to express what your wishes are. A HIPAA release deals with authorization to medical providers for your power of attorney and your healthcare proxy to be able to make informed decisions, medical decisions for a healthcare proxy and for an agent under a power of attorney in dealing with any billing matters. A burial designation. This is important. You know, this becomes an important document oftentimes in second marriages, where we have a step parent and children, and sometimes they have a difference of opinion as to what happens to your remains at death. And so New York State has a document called Appointment of Agent to Control Disposition of Remains. And on that, you set forth who you want to have authority to make those decisions and what your wishes are regarding the disposition of your remains. I'm going to go back to the previous slide because I failed to mention something under the estate tax planning is just what our limits are, our thresholds, our exclusion amounts are currently. From the federal level, we've had an increase with the recent Tax Act earlier this year, and we have $11,180,000 exemption individually. So if you're married, it's double that amount. Okay, so we have had such large increases in the federal estate tax exemption. Now that is set to end under current legislation at the end of 2025 and revert back to the old law in 2026, absent any new legislation, which was around $5.5 million range, subject to inflation. New York State still has an estate tax. And we have an exclusion amount of $5,250,000, which has set to increase as of January 1st to $5,740,000. New York State taxes differently than it does on the federal level, in that if you're $1 over the exclusion amount, you get taxed on your entire estate. So not anything over the $5.25 million amount, but back to $1, up to a maximum of 16%. Okay, so what is all this? So I'm providing all this background and education to you to get to the point of where do we also, and I still have a little bit more to go, but where do I find my clients getting themselves into trouble? Or they come to me when the troubles happen, and we have to help them to fix things. So back to just a few more things with estate planning essentials. So it's important. So this here, these are the legal documents that you need to have in place. Your will, sometimes a trust, coordinating beneficiary designations, and your advance directive. So these are the actual documents. Then what else do you need in terms of globally looking at your estate planning? Well, you need a list of assets. And on that, it should list what your banking accounts are, your investment, retirement, life insurance, and it includes contact information and account numbers. A list of usernames and passwords. Now, it's always difficult. Where do you keep that information? Do you keep it on the computer? And does your computer have a password to log on? Or do you keep it written down somewhere? Do you have a safe deposit box? If you do, where is it located? Where's the key? Proof of ownership of your deed to your home, your title to your car, title to a boat or other assets. So all of this can be put onto, all of this information that I have in these first 4 bullet points, you can encompass in a letter of instruction to your executor or trustee, your fiduciaries. And a letter of instruction provides an easy kind of shortcut for your fiduciaries to know what assets we're dealing with, how to reach out to the various entities. And it's kind of like, I like to say it's a cheat sheet, but it saves significant time and money and running around to have this letter of instruction with this information on it. Also, I think an estate planning essential is hire somebody who's professional in doing this. There's online do-it-yourself wills. I have yet, and I've been doing this for over 15 years, I have yet to see a will that from a online company that did not have mistakes in it or was not executed properly according to New York law. There was a situation most recently where I met with a individual who I didn't represent both the husband and wife, but the husband, was married to his second spouse and had children from a prior marriage, and the distribution just did not protect for his intention of providing for both his spouse as well as guaranteeing that assets would be distributed to his children upon his spouse's death. Other times, I have seen where the wills were not executed properly, and it's going to cause issues through the probate process. And the problem is oftentimes these mistakes cannot be cured, or if they can, the issues are not known until you're deceased or you're incapacitated and it's too late to fix it. The other thing is, everybody knows a lawyer, but lawyers, especially over the last, decade or two, have really become specialized, and they concentrate in certain areas of the law. I had a situation a couple years ago where I was presented with a will for that a divorce lawyer prepared. Her specialty was matrimonial law, and because it was a lawyer and the family friend that they knew, and the lawyer wanted to do the right thing and help the family out. And they had two children, and both children had significant disabilities, where we had to establish where they were on government benefits because they were actually in a residential placement in New York, what we refer to often as a group home, and and so their assets were distributed, their will distributed assets into a special needs trust upon their death. But then within the contents of the trust, it said that when the child dies, the adult child, assets are payable back to New York State to pay back Medicaid, which is not required whatsoever in New York. Is that because it's a third party, and that's beyond the scope of today's presentation. But with a third party supplemental needs trust, there is no required payback under the law to pay back Medicaid. So we had to go through a very costly, time-consuming. The case actually took about 2 to 3 years to work its way through the court to resolve itself. We had to go back to the lawyer and ask for an affidavit, which is difficult because the lawyer certainly doesn't want to admit that they may have done something incorrect, and to be able to fix this. And fortunately, we were able to fix it, but not without the family having to expend a significant amount in legal fees and time and stress, a lot of stress. So, needless to say, the important thing here is it's worth, hiring the right lawyer, spending the money to get the job done properly, so that you can take comfort in knowing that when these documents are ready to be used, whether it's a power of attorney or a trust or a will, that they were prepared properly. Sorry, moving on to my next. Okay. So you need to think about your fiduciary selection. So I talked about this before, that sometimes the power of attorney and the trustee are the same, individuals, but sometimes they're not. The most common fiduciaries that you're choosing to help you in your estate are an executor who handles the probate, which I mentioned before. That job can last anywhere from 9 months to 2 years, if not longer. Then you have a trustee whose job will last as long as the trust is in place. So some trusts are in place for the beneficiary's entire lifetime. And then we have a guardian over minor children and even adult children who have incapacity and aren't able to execute their own advance directives. We have power of attorney, which deals with financial affairs during your lifetime, and healthcare proxy medical decision making. So you have all these different roles, and not only is it difficult sometimes for families to be able to find one person to fill these roles, but then I always ask for at least a standby or a successor person, because if the primary person is not able or not willing to act, because just because you name them does not mean that they agree to the job if you have not discussed it with them ahead of time and they're blindsided, when an emergency happens or your death, that they were put in this role that they didn't agree to. So first of all, it's important to have that conversation to make sure that they are willing to act as your fiduciary in whatever capacity. In terms of choosing executors and trustees, sometimes we consider corporate fiduciaries because there's not appropriate family members to be able to serve in these capacities, whether the family dynamics just won't, they won't be effective from that perspective. Sometimes we're dealing with adult children who have, disabilities that is going to last their entire lifetime, and sometimes the sibling is not the appropriate person to fulfill that role. So you want to just think about your fiduciaries very carefully. In choosing a healthcare proxy, who is going to honor what your wishes are? If it's going to be difficult for them to make what the wishes say end of your, withdrawal life support, if that was your wish at the end of your life, but they're going to have a very difficult time doing that, then they're likely not the most appropriate person to choose. It's important to have these conversations. The other thing is think about, another situation I had a few years ago is that the trustee of the children's trust and the guardian were different individuals. And it so happened that both parents died, and we were dealing with minor children and an inheritance that was in trust. And the individuals who were serving as guardian and trustee did not get along at all. And everybody hired their own lawyers, and we were in court a lot for several years. And who paid for that? Who paid for us lawyers? It's the trust that pays for it. And so, just keep in mind when you're choosing these roles to think about the selections. And I understand that some families want the check and balance to not put everybody in the same role. But but on the other hand, think about the relationship of these various individuals. One other item here that I don't have written down here, but is becoming increasingly popular, is what's called a trust protector. So oftentimes we'll have families designate a corporate trustee to serve as trustee of their trusts or children's trusts, and that trustee is fantastic now, but maybe they're not going to be fantastic 20 years from now or 30 years from now. And we give a family member the ability to change that trustee, to basically fire them and put in place another trustee or another corporate trustee. So that's something that to be considered and discussed as well. One thing, and I don't think I have this on my slides, but I'm a big proponent of discussing your estate plan with your family or your decisions. You don't have to go into great specific detail, although I think it's important. You don't have to necessarily show them your estate planning documents, but I have oftentimes families that don't leave what you would consider a traditional distribution of their assets upon death, and that they would leave everything to their surviving spouse and then equally to their children. Well, sometimes if we're dealing with children that have extra needs, families want to leave more money to that child with extra needs because they feel that their child's not going to be able to have the earning capacity during their lifetime, and they're going to rely solely on whatever government assistance they can receive, as well as what they receive from their mom and dad. And so maybe mom and dad decide to leave 60% of their estate to that child with extra needs or special needs, and 40% to the other child or children. Or maybe there was a loan, so maybe in another scenario, mom and dad loaned a child money throughout the years, but did not loan the other child money. They kind of want to make up for it through their estate plan by leaving the child they haven't loaned money to more money. Perhaps that child, the other child who was loaned money, doesn't know the reasoning behind that. So to the extent that it's, it's non-traditional equal split, I think it's important to discuss that with your family members. Otherwise, when you die, it leads to a lot of animosity, a lot of hurt feelings, and sometimes significant litigation between the beneficiaries for their feeling that they weren't treated fairly. So other common mistakes, failure to plan for incapacity. Incapacity affects many of us, many of our family members, and Alzheimer's is on the rise, and we're all living longer. So it's critical to have the proper planning in place. The affordability, if you cannot self-fund any type of long-term care and you do not have long-term care insurance, how are you going to pay for it? Proper planning and considerations need to happen there. What if a family member becomes disabled? What if you become disabled? Think about all different types of plans that could be put in place and protections for any beneficiaries that may be disabled. I always, when I'm working with a family, I always, and even with young families that are 30s and 40s, I talk about their grandchildren. So I'll say, well, what if I know that you only have children that are ages 2 and 4 years old, but this is you're 40 years old, and this is the first will you're doing. What if you don't do another will? Okay, we want to plan and think about in the future. We want to think about what happens to your immediate family and something happens in a common disaster, or they're young when they die. How do you want your estate distributed? So it's not a conversation that's easy to be had. It's certainly not something that none of us want to think about, but you want to have the control in deciding who inherits in the unlikely event of some type of, all of the, entire family perishing. Failure, I touched upon this a little bit before, but failure to properly title assets and update beneficiary designations. So before I mentioned that the planning between your will and any trust and your life insurance and your retirement plans all needs to be coordinated. It's important that it's all that you discuss it with your lawyer, because so that all of it can be properly planned, and that you give the attorney the ability to also speak with your financial advisor and coordinate that way, because in that your financial advisor likewise knows about your attorney, so that everything is properly coordinated. So failure to fund trust. So this is, with revocable trust. So if I get a family that comes to me and says, we want to avoid probate, Amy, how do we avoid probate? So I want a revocable trust. So that's what I want. I want a revocable trust. Okay, great. I prepared a revocable trust for you. And if you don't retain me to help you fund it, say that you want to do it on your own, remember, do it yourself, you need to make sure that you fund those trusts. Because if you don't fund the trust, you are not avoiding probate, if that's your goal, because you're going to end up back through the court system, and even though your will, they say I pour over, I leave everything to my revocable trust, you still have to go through the probate process. Failure to consider tax planning. So oftentimes people think about estate tax or gift tax. Well, those aren't, in my opinion, which affect many of us, even though we're in the New York and Westchester, the downstate area, where people tend to have a higher net worth. But I think that what the biggest part that clients fail to consider is capital gains planning, or in income tax planning, but really the capital gains, because I'll meet with families that say, I want to avoid probate, or I want to do asset protection, and in case I need Medicaid, I want to just give my child all of my assets, or I want to change the deed from my own name into my child's name so that I could protect it. the issue is that I will routinely meet with people that they purchased their home for under $100,000, $35,000, $75,000, and now it could be upwards of valued at $800,000 or more. If you transfer highly appreciated assets to your children during your lifetime, you're going to lose, without doing proper planning, they could get hit with a very significant capital gains tax when that asset is sold. Whereas there's different mechanisms through irrevocable trusts or revocable trusts, or just by operation of taxing at death, where you're able to take what's called a step up in basis in the asset to minimize or to eliminate capital gains to the most part for the transfer of assets. So it's really important to consider that, as the estate tax does not affect many of us, the gift tax certainly doesn't, even though I feel that that's also a common misconception, because New York does not have a gift tax. So you could give away, capital gains aside, you could give away an unlimited amount of money or assets to an individual and have no New York State gift tax, because we have none. But you do have an estate, a federal gift tax, which is linked to the state tax, which is close to $11.2 million. It's just under that. But so, again, the gift taxes don't impact most of us from a day-to-day perspective. So I have clients that will say, well, I could only give $15,000 a year, which is the annual exclusion, which used to be $10,000 a year, and now it's up to $15,000. But I explain to them that that $15,000 freebie gift is fine, but if you give more than that, let's say you give $100,000 away or $115,000 to somebody during the year, the $15,000 is written off as an annual exclusion. You don't have to report that. And then the $100,000, what happens is it chips away at your federal lifetime, estate and gift tax exclusion, which I mentioned before, is just under $11.2 million. So now you only have $11.1 million estate and gift tax exclusion. So that's all that happens from a gift tax perspective. But what's critical is to consider the appreciation in assets from a gain perspective. Other common mistakes: hiding your documents, putting them somewhere and not letting family members know where those documents are. You don't, like I said before, you don't need to share the documents, but you should at least know where have individuals in the event of emergency know where to locate your healthcare proxy or your power of attorney or your will. If your will, typically with any document aside from a will, a copy is sufficient. However, if your original will cannot be located at your death, it's presumed that it's been revoked and you cannot collate a copy of your will. So it's very important to let your family know where your documents are. Putting them in a safe deposit box is not always in your best interest either, because the safe deposit box can be sealed or can be locked, and then you have to go through a court proceeding, or your fiduciary has to go through a court proceeding to have it unsealed. Writing on your documents, excuse me one second, I just have to take a sip of water. Writing on your documents. So every once in a while, I will see somebody, cross off, they left a specific bequest to their grandnephew of $10,000, but they wanted to change it to $25,000, so they crossed it off and wrote on top of that $25,000. The court's not going to honor that. It's not effective. It's not legal from the court perspective, and it subjects your will to challenge. What if you wrote down $100,000 and then you cross it off and change it to $10,000? Well, now you're going to have a beneficiary that's pretty mad that they saw that they're originally getting $100,000 and now they're only getting $10,000, and they may feel the need to legally challenge that. Actually, they probably would be successful from that perspective, because they were getting more, and the court's not going to honor that. But the other Individuals in the family may want to challenge that because, it's showing that your intention was to leave less. I mentioned this before, not coordinating your estate plan with your financial planner and accountant. Sharing prior planning with a new lawyer. This comes up from time to time where I'll meet with a new client that did previous planning and wasn't sure. They may have had an insurance trust or had some type of, a revocable trust that they did, but don't worry about it, Amy, it's so long ago, nothing happened. But what if there was? And it's important, it's just important to be able to share whatever you've done in the past with your new lawyer so that your planning can be complete and comprehensive and there's no loose ends. You also need to review your estate planning on a regular basis. And I'm going to come to that in a little, actually, I think on the next slide. So reviewing your estate plan. Minimum, if there's an illness in your family, a disability or death of a beneficiary or fiduciary, that's a trigger to, meet with your lawyer to have everything reviewed. If your child is getting married or you're getting married or going through a divorce, remarriage, any beneficiary, either yourself or any beneficiary. Change in fiduciaries, if you're retiring. These are really the triggers for you to talk to your lawyer, to have a meeting and see if there needs to be any changes. Sometimes there doesn't need to be changes. Everything's good, but it's good to have that reviewed and blessed, every so often. And, do you have a change of distribution of assets? Did you recently receive a large inheritance from a parent and now it changes your situation? Do you move to another state? So as I mentioned before, advance directives are very state specific. Some states, for example, on a will require 3 witnesses, where other states only require 2 witnesses on a last will and testament. So it's important that if you move here from another state to have documents reviewed. If you move from New York to another state, meet with a lawyer in the new state and have the documents reviewed. Name change. I would say at minimum, review your documents, pull them out of wherever you have them, hopefully not in hiding, review them every 3 to 5 years just to see if anything changes, or to have a meeting. In our office, we offer clients who have done their estate plan with us, what's called a peace of mind program. And it's for a small biannual fee, every 2 years, they pay a small fee, and it includes a meeting once a year and telephone calls and emails and our ability to talk with their financial advisor and planner for us to really stay connected and with clients so that when these life emergencies or life happens, situations happen, we're right in front and center in their mind for them to call us or reach out to us so that we could assist them as necessary or update documents as necessary. Just little action items. Stay educated. If you missed anything or you came on late on this webinar, I think that we're going to be posting it on our website, so stay tuned for that. Meet with your attorney regularly, review your estate plan. I've really gone through all of this, but I don't see any questions. So, Kian, can you please, I don't have any questions that came up on my chat, so maybe there are none. Which is certainly fine, but usually I have questions that come up, so I want to make sure that there are no questions that are popping up. Okay, so Cam got a question, but it's not showing up on my screen, so bear with me. Okay. So are the slides available as a handout? I think they are, Kian. So if you could email, it's on the contact email that where the marketing, and they'll be able to send you a PDF of the handout. Is it advisable to have a will with an executor that also names the trustees to manage transfer and death accounts, will to minor children? So first of all, okay. Names the trustees to manage transfer and death. Yeah, so I'm not sure exactly I understand the question, but You can have, it depends if the testamentary trust, or if the trust for your minor children is what we refer to as a testamentary trust under your will, or is it through a revocable trust. But in any situation, the trustee will manage those assets and will manage those assets. But sometimes if it's a transfer on death, that typically avoids, and maybe this is getting to your question, that typically avoids the probate, and the executor is really not going to have control or responsibility to marshal those assets. But because it's a transfer on death to a named trust, the trustee is going to take over and manage that. Okay, I think there may be a couple more questions coming through, so bear with me, because we're doing this a little bit different because it's not coming up on my screen. And we move to, okay, so if I live in Massachusetts, and the trust is Massachusetts, and we move to New York, do I need to have a different trust, or is it good state to state? The answer is it depends, and it needs to be reviewed. It may be perfectly fine, but it's worth a consultation with a lawyer to have it reviewed, because it may need some changes. The executor is one. What's the, bear with me, I'm just, okay, what's the okay, so here's a question more about estate litigation. What should you do if the will stipulates you won't receive anything if you question the validity of a will? So that is a different presentation about estate litigation, but first you have to have standing to be able to contest. So if you have that standing, which is, there's a different ways to determine whether you have standing, then you may have the ability to contest test that will. So that is, it's a very specific question, so I think it depends is the answer. But that would ultimately result in some type of estate litigation. Then some of the tax webinar, what are the tax exemption limits for special needs trusts in New York? Well, that is a separate presentation about, because I didn't go into that today, but there's income tax. There's different ways to structure a special needs trust from an income tax perspective, whether you make it revocable to yourself, whether we give it what's called qualified disability trust status, or a grantor trust status. So that's a different topic that I actually didn't go into detail about at all today. But stay tuned for future webinars on special needs planning, because I will talk about it sometimes in those. Okay, bear with me, because something else. Did I miss one here? Bear with me. I'm looking at, okay. Okay, the executor is one parent and the trustee is the spouse. I don't think I understand that question of what I talked about before, but because usually assets don't get funded into a trust until the second spouse dies. But it certainly can happen when the first spouse dies and you kind of bifurcate your estate and leave certain part to your, just directly to your children and not to your spouse. They can serve as a trustee, certainly. Can you just answer me if there's going to be a recording available of this? I think it will be on our website. Can you just confirm yes or no in your text to me? I think I got all the questions. Yes, the recording will be available. All right, well, thank you very much for joining us today. I appreciate it, and thank you for listening. Bye-bye.